Do you have a child that's turning 18 or recently turned 18? Do you know what kind of estate planning documents they might need? My name is Amanda Rocha. I am an estate planning and probate attorney in California, and I'm answering this very common question for you today. Before I get into that, I want to give you my contact information. You can find me on my website, www.amandarocalaw.com. You can follow along on my social media at Amanda Rocha Law, or you can comment down below if this platform allows you to do that. So why would an 18-year-old even need estate planning documents? That's a good question. I do have many clients whose children are either minors or adults. And for the minors, you don't really need to do anything about estate planning for them. They are going to deal with that later on. When they become an adult, however, you do not have any power to do anything for them anymore. You can't make healthcare decisions on their behalf. You can't go to the bank and help them because you're their parent. You can't really do anything that you couldn't do for any other adult just because they were once your minor children. So what I recommend for my clients who have children who are young adults who don't really have a need to have a full estate plan for themselves, but they do need some protection, is that they get a few key documents. The very most important one is an advanced healthcare directive. This document contains two sections. The first section is a healthcare power of attorney. In that section, you're naming a person to step in and make healthcare decisions for you if you are incapacitated or unable to do so yourself. The second section is your living will, and that talks about your preferences when it comes to medical treatment when you can't say so. The second document that I recommend is a durable power of attorney, and that document lists a person to step in and make decisions on your behalf for anything outside of healthcare if you are incapacitated or unable to do so. These two documents together, the advanced directive and the power of attorney, they do not have to give someone an immediate power. In fact, most of the time they do not. They use what's known as a springing power, and that is a power that gives the agent, the person you've listed as your future power of attorney, it gives them power only when doctors have decided that you are incapacitated. They can determine that based on the criteria we would put in the paperwork, but also you can decide how many doctors make that decision. If you want it to be just your primary care physician, you can do that. If you want it to be 2 licensed physicians, that's the most common, or a panel of doctors. And there's no court involvement necessary. Whereas if something were to happen to your child without one of these documents, you would need to go and get a conservatorship. That costs a lot of money, takes a lot of time, and you might not be able to make the proper decisions in the meantime while your child needs the help. So this is a dormant document with a springing power, these two are at least, springing powers that allow you to step into action when you need to, and then as soon as they've regained their capacity to make decisions, then your power goes away. So there's no permanent power that you have over them. You won't be able to go and check on their bank accounts or anything like that. But it is a safety precaution because if something were to happen to them and they got into an accident, you could step in and help. The other document that I recommend that they have is a HIPAA authorization. And this is not like the HIPAA forms that you fill out with a doctor. This document actually lists people who are allowed to check in on their status if they are unable to give status themselves, so they're usually incapacitated. On this document, you will have generally your close family and friends, people who are not necessarily your healthcare power of attorney, but other people that you want to be able to check in but make no decisions on your behalf. Those 3 documents are very important, and I recommend that everybody over the age of 18 has them. Now, depending on what your 18-year-old or 20-year-old has, they may also want to have a will, and some of them would require a revocable living trust, but usually not at that young of an age unless they are fortunate to own property or multiple assets. If you have questions about this, please comment down below or follow along on my social media at Amanda Rocha Law. Send me a message there or make a comment on one of my videos. Or you can schedule a strategy session with me on my website, www.amandarocalaw.com.